If you are a naturalized United States citizen, 2026 may be the most important year for your immigration status since the day you raised your right hand and took the oath. Over the past several weeks, headlines, social media posts, and viral WhatsApp messages have been spreading one alarming claim after another that the Trump administration's new immigration policies could put naturalized citizens at risk, that citizenship is no longer secure, that denaturalization cases are quietly expanding behind the scenes. Some of what you're hearing is exaggerated, some of it is misunderstood, and some of it is rooted in real policy changes that deserve careful attention. The problem is that fear spreads faster than facts, and in an environment where immigration enforcement has clearly intensified, it becomes very difficult to separate rumor from legal reality. So the real question is this: can your U.S. citizenship actually be taken away in 2026? Are naturalized citizens being targeted? And what has truly changed under President Trump's renewed immigration agenda? Not politically, not rhetorically, but legally. Because there is a massive difference between campaign language, agency enforcement priorities, executive authority, and constitutional protections. And if you don't understand those differences, it's easy to panic. Today, we are going to break this down clearly and calmly. What's new? What isn't new? Who is genuinely at risk, and what you should and should not be worried about right now. Hi, I'm Sophia, and welcome back to US Entry Point. If you've been following this channel, you know that my goal is simple: to give you clear, legally grounded, and up-to-date immigration information without political spin, without sensationalism, and without fear-mongering. Immigration law in 2026 is changing rapidly. Policies are being updated. Enforcement priorities are shifting. Court challenges are unfolding in real time. And when that happens, confusion spreads quickly, especially inside immigrant communities where people are understandably protective of everything they've worked so hard to build. So today, we're doing a full legal breakdown of the new rules and enforcement updates affecting naturalized citizens under the Trump administration. Not rumors, not speculation, the actual legal framework. Because once you understand how citizenship is protected under the Constitution, how denaturalization actually works, and what enforcement expansion really means in practice, you'll be able to replace uncertainty with clarity. And that clarity matters, especially right now. Before we go any further, we need to separate something that almost always gets blurred together in public conversations about immigration: political messaging versus legal authority. President Trump returned to office on January 20th, 2025. And from day one, his administration made it clear that immigration enforcement would be a top priority. Speeches emphasized border security, interior enforcement, and accountability for fraud within the immigration system. Executive orders directed agencies to review policies. Funding was reallocated toward enforcement divisions. All of that is real. But here's what's equally real. Campaign rhetoric is not the same thing as constitutional law. An administration can change enforcement intensity. It can redirect agency resources. It can reinterpret certain regulatory standards within existing law. But it cannot simply rewrite the Constitution with a press conference. That distinction matters more than anything else in this conversation. When people hear that enforcement is increasing, they sometimes jump to the conclusion that rights are disappearing. That's not how the American legal system works. The executive branch enforces the law. Congress writes the law, and the Constitution limits both. So yes, enforcement posture has hardened in 2026. Yes, agencies like USCIS and the Department of Justice have been directed to increase scrutiny in certain areas. But the structural legal protections around citizenship, especially naturalized citizenship, are not political suggestions. They are constitutional guarantees. And that brings us directly to the foundation of this entire discussion. What protects a naturalized citizen in the first place? The answer begins with the 14th Amendment to the United States Constitution. It states in plain language that all persons born or naturalized in the United States are citizens of the United States. That phrase, born or naturalized, is critically important. It does not create two different tiers of citizenship. It does not suggest that one type is permanent while the other is conditional. The Supreme Court has repeatedly affirmed that once someone is lawfully naturalized, they stand on equal constitutional footing with someone born on American soil, equal rights, equal protections, equal status under the law. Now, does that mean citizenship can never be revoked under any circumstances? No. And this is where nuance becomes essential. There is a legal process called denaturalization. It has existed for decades. It is not new to 2026. Denaturalization is the formal process through which the government can attempt to revoke citizenship if it can prove that the person was not legally entitled to it in the first place. Notice the phrasing there. The focus is not on punishing someone for being a citizen. The focus is on correcting a citizenship grant that, according to the government, should never have happened because of fraud or illegality during the naturalization process itself. Under Section 340 of the Immigration and Nationality Act, the government may pursue denaturalization if citizenship was illegally procured or obtained through concealment of a material fact or willful misrepresentation. Those words carry very specific legal meaning. Willful means intentional. Material means significant enough that it would have affected eligibility. This is not about minor paperwork errors or forgetting a short trip abroad. It is about deliberate deception that would have changed the outcome of the application. And even when the government believes such deception occurred, it cannot simply cancel citizenship administratively. It must file a civil lawsuit in federal court. That means a judge is involved. Evidence must be presented. The burden of proof falls on the government, not on you, and not just any burden of proof. The standard is clear and convincing evidence, which is higher than the standard used in most civil cases. You have the right to hire an attorney. You have the right to defend yourself. You have the right to present evidence and cross-examine witnesses. If the court rules against you, you have the right to appeal to a higher court. This is a structured judicial process, not a backroom administrative cancellation. Historically, denaturalization has been rare, extremely rare. For many years, the number of cases filed annually was measured in the dozens, not thousands. These cases typically involved serious misconduct, concealed war crimes, undisclosed terrorism affiliations, false identities, or clear marriage fraud schemes that led to green cards and eventually citizenship. The rarity of these cases reflected how seriously the legal system treats citizenship. Courts have consistently emphasized that stripping someone of citizenship is one of the most severe civil penalties the government can impose. It is not done lightly. So if constitutional protections are strong and the legal standard is high, why is there so much concern in 2026? Because while the Constitution hasn't changed, enforcement intensity has. And enforcement intensity can shape how frequently these cases are investigated and brought to court. That's the shift we're seeing. Not a rewriting of citizenship law, but a more aggressive use of an existing legal tool. And understanding that difference is the key to evaluating your real level of risk calmly and rationally instead of emotionally. In other words, the foundation remains intact. The Constitution still protects naturalized citizens. The courts still require due process. The government still carries the burden of proof. But the machinery reviewing past cases is operating at a higher speed than it has in previous administrations. The next question, and it's the one that matters most, is how that increased enforcement actually plays out in practice and who it realistically affects. So what has actually changed in 2026? Not the Constitution, not the statutory definition of citizenship. What has changed is enforcement posture. And that shift is happening inside federal agencies in ways that don't always make headlines, but absolutely shape outcomes. Since early 2025, the Department of Justice has expanded resources dedicated specifically to denaturalization review. The specialized unit that handles these cases, which existed before, has reportedly received additional staffing, updated investigative tools, and stronger directives to revisit older naturalization files where fraud was previously suspected but never pursued. At the same time, interagency data sharing has improved significantly. Government databases that once operated more independently are now more integrated. That means information from criminal records, immigration filings, asylum applications, visa petitions, and even certain international data sources can be cross-referenced more efficiently than in prior years. In practical terms, what does that mean? It means older cases are being re-examined with modern technology. Applications filed 10, 15, even 20 years ago can now be digitally compared against records that may not have been easily searchable at the time. If someone used a false identity decades ago and that identity now matches biometric or fingerprint data in a criminal database, it can be flagged. If someone concealed a serious conviction abroad that later appears in international information sharing systems, it can be detected. The system is more technologically capable than it was in the early 2000s, and the administration has made it clear that it wants those capabilities fully utilized. But here's the part that often gets distorted online. Increased review does not equal mass revocation. Even with expanded enforcement, we are talking about hundreds of denaturalization cases per year, not millions. The overwhelming majority of naturalized citizens will never receive a notice, never be contacted, and never face a challenge to their status. The cases that are being prioritized tend to fall into very specific categories. Individuals who concealed involvement in war crimes or human rights abuses. Individuals who failed to disclose serious criminal convictions that would have made them ineligible for naturalization. People who obtained green cards through proven marriage fraud schemes. Applicants who used fraudulent identities, or individuals tied to terrorist organizations or extremist groups that would have disqualified them at the time of application. If you were truthful on your naturalization forms, if you met the eligibility requirements, and if you did not hide disqualifying information, your constitutional protection remains intact. That is not political reassurance, that is legal structure, and it's important to repeat it clearly. Denaturalization is about alleged fraud in obtaining citizenship, not about punishing someone for being unpopular, politically active, culturally different, or critical of the government. If this type of clear fact-based breakdown is helping you understand what's actually happening beyond the headlines, make sure you're subscribed to US Entry Point and that notifications are turned on. Immigration enforcement policy in 2026 is evolving quickly, and staying informed through reliable analysis, not viral rumors, can make all the difference. Now, while denaturalization applies to people who are already citizens, another significant shift in 2026 affects those who are still in the naturalization process. USCIS has implemented more rigorous vetting procedures for new applicants. The civics test itself has not officially changed in structure, but interviews have become noticeably more detailed. Officers are spending more time reviewing travel history, employment records, tax compliance, and prior visa applications. Requests for evidence, commonly called RF, have increased in frequency, especially in cases involving extended travel outside the United States or complicated immigration histories. Processing times have also lengthened in many jurisdictions. Applications that once averaged 12 to 18 months are now in some areas taking 18 to 30 months or longer. That doesn't mean approval rates have collapsed. It means scrutiny has increased. Officers are documenting cases more thoroughly. Supervisors are conducting additional internal reviews, and background checks are more layered than before. And here's something important that many applicants misunderstand. The test isn't harder, but the verification is deeper. Officers are paying closer attention to consistency. If information provided during the interview does not match prior filings, even older visa applications, it may trigger follow-up questions. That doesn't automatically mean denial, but it does mean preparation matters more than ever. For green card holders watching this distinction is critical. If you are not yet a citizen, your permanent resident status does not carry the same constitutional permanence as citizenship. Lawful permanent residents can lose their status under a broader range of circumstances than naturalized citizens can lose theirs. Certain criminal convictions, extended absences from the United States, or misrepresentations on applications can place a green card at risk. That's precisely why, if you are eligible for naturalization, Applying for citizenship is often the strongest legal move you can make. Citizenship provides protections that permanent residency simply does not. At the same time, if you are eligible and applying in 2026, you must approach the process carefully. Review your entire immigration history before filing. Make sure prior applications were accurate. Confirm that your tax filings align with your reported employment history. If there were complications in the past, arrests, immigration violations, extended trips abroad, consult with a qualified immigration attorney before submitting your N-400 application. Enhanced scrutiny doesn't mean automatic denial, but it does mean preparation is no longer optional. So, we now have two parallel realities in 2026. More aggressive review of past naturalizations where fraud is suspected, and more intensive vetting of new citizenship applicants. Neither equals automatic loss of rights, but both reflect an enforcement climate that is stricter than what many immigrants became accustomed to in prior years. The next question, and it's one I know many of you are asking, is who specifically faces real legal risk in this environment and who does not? To understand the real level of risk in 2026, we need to zoom out for a moment and look at the broader enforcement climate. Because perception is often shaped less by individual cases and more by the overall atmosphere. Beyond denaturalization reviews and stricter naturalization interviews, the Trump administration has expanded several enforcement mechanisms that affect non-citizens. Expedited removal procedures have been broadened in geographic scope and time applicability. That means certain individuals who cannot prove continuous presence in the United States for a required period may be subject to fast-track removal without seeing an immigration judge. Workplace enforcement operations have increased with more frequent audits and targeted investigations of employers suspected of hiring undocumented workers. Cooperation agreements between local law enforcement and federal immigration authorities have also expanded in some jurisdictions, reducing the insulation that so-called sanctuary policies once provided. Now, if you are a naturalized citizen, expedited removal does not apply to you. Workplace raids are not designed to target U.S. citizens. Local police cooperation with ICE does not override constitutional protections. But here's where anxiety creeps in. When enforcement intensifies in immigrant communities, generally fear doesn't stop neatly at the boundary between citizen and non-citizen. Communities are interconnected. Families are mixed status. A green card holder may be married to a citizen. A citizen may have undocumented relatives. So even if the legal risk is limited to specific categories, the psychological impact spreads more broadly. That's why clarity is so important, because while enforcement has expanded, the legal threshold for denaturalizing a citizen has not quietly dissolved. It remains tied to fraud or illegality during the process of obtaining citizenship. So who is actually at risk? Let's break this down precisely. First category, individuals who knowingly lied during the naturalization process about something material. That could include failing to disclose a serious criminal conviction that would have made them ineligible, concealing participation in human rights abuses, or hiding membership in organizations that legally bar eligibility. Material is key. It means information that would have changed the decision. Forgetting a speeding ticket is not material. Intentionally concealing a felony conviction very likely is second-category individuals who obtained lawful permanent residency through proven fraud such as a sham marriage and later naturalized based on that fraudulent green card. If the foundation was fraudulent and can be proven as such, the naturalization that followed can be challenged. Third category, individuals who used false identities, fake documents, or multiple identities during their immigration process. With improved biometric systems and database cross-referencing, identity discrepancies are easier to detect today than they were 20 years ago. Fourth category, individuals tied to terrorism-related grounds of inadmissibility or serious human rights violations that were not disclosed. These are rare cases, but historically have been among the most aggressively pursued. Now, let's address something that is widely misunderstood. Crimes committed after naturalization by themselves generally do not cause loss of citizenship. If someone becomes a citizen lawfully and then years later commits a crime, they may face criminal prosecution. They may face prison, but they do not automatically lose citizenship simply because of that later offense. The exception would be if the crime reveals that the person lied during the naturalization process. For example, if someone stated under oath that they had never committed certain crimes, but later evidence proves the crimes occurred before naturalization and were concealed, that's different. The issue goes back to fraud and procurement. Another widespread myth is that speaking your native language, holding dual citizenship, criticizing the government, or traveling frequently to your home country can jeopardize your citizenship. There is no law that revokes citizenship for cultural retention or political disagreement. The United States does not require you to erase your heritage in order to remain American. Dual citizenship is recognized in most circumstances. Visiting your country of origin is not grounds for denaturalization, and political speech, even harsh criticism, is protected by the First Amendment. There's also fear circulating that certain nationalities are being broadly targeted. While it is true that certain regions of the world may receive heightened security screening in visa processes, there is no statute that allows blanket denaturalization based on national origin. Denaturalization cases must be based on individual evidence of fraud, not ethnicity or birthplace. So here's the honest picture. The vast majority of naturalized citizens who were truthful, who met eligibility standards, and who did not conceal disqualifying information are not facing a realistic legal threat. The individuals most vulnerable are those whose original applications contained deliberate material deception. That's a narrower category than social media would have you believe. But knowing that still leaves an important question. What happens if someone is actually contacted? What rights do you have if the government questions your citizenship status? And how should you respond in a way that protects you legally instead of making a stressful situation worse? That's what we're going to break down next. If you are ever contacted by a government agency about your citizenship, whether it's a letter from the Department of Justice, a notice from USCIS, or a request to appear for questioning, the most important thing you can remember is this: you have rights. And those rights are not optional. They are constitutional. First, you have the right to remain silent. You are not required to answer questions on the spot without legal counsel present. If an investigator contacts you and asks to clarify something about your naturalization file, you do not need to panic, but you also do not need to start explaining your entire immigration history in that moment. A calm, respectful response such as, "I would like to speak with an attorney before answering any questions," is completely appropriate. Exercising your right to counsel is not an admission of guilt. It is a legal safeguard. Second, if the government formally initiates denaturalization proceedings, it must file a civil lawsuit in federal court. That means a judge oversees the process. You have the right to hire an attorney and mount a full defense. These are not administrative cancellations done behind closed doors. They are judicial proceedings with evidentiary standards and procedural protections. Third, the burden of proof is on the government. This is critical. You do not have to prove that you deserved citizenship. The government must prove with clear and convincing evidence that you obtained it illegally or through willful misrepresentation. That standard is intentionally high because courts recognize how serious it is to strip someone of citizenship. Fourth, you have the right to appeal. If a federal district court rules against you, the case can move to a federal appellate court. In rare cases, legal questions can even reach the Supreme Court. The system is layered and outcomes can change at different stages. Fifth, legal principles like issue preclusion and protections against repetitive litigation generally prevent the government from trying the exact same denaturalization claim repeatedly if it fails the first time. The system is not designed for endless retrials of the same accusation. Now, let's move from legal theory to practical preparation. Even if you believe you have nothing to worry about, being organized and informed is simply smart. Start by keeping all immigration-related documents in a secure and accessible place. That includes your certificate of naturalization, copies of your N-400 application, your green card if you still have it, prior visa applications, approval notices, and any correspondence with immigration authorities. If you applied many years ago and do not have copies, consider requesting your immigration file through a Freedom of Information Act request, so you know exactly what was submitted under your name. If you have any complex history, prior arrests, immigration violations, extended absences from the United States before naturalizing, or discrepancies in earlier applications, it may be wise to consult an experienced immigration attorney proactively. This does not mean you are in danger. It means you are informed. An attorney can review your file and identify whether anything raises legitimate red flags under current enforcement priorities. Do not ignore official notices. Sometimes people assume a letter is a mistake or spam and delay responding. That is one of the worst decisions you can make. Deadlines in legal proceedings matter. If you receive any communication referencing your citizenship status, act immediately and seek professional counsel. For those of you who are not yet citizens but are on the path, green card holders in particular, there is another important warning. Never falsely claim U.S. citizenship on any document. Not on a voter registration form, not on a job application, not on a government benefits form. A false claim to U.S. citizenship can trigger permanent immigration consequences and is far more difficult to overcome than many other violations. If you are unsure how to answer a question on any official form, consult an attorney before submitting it. If this breakdown is helping you distinguish between real legal risk and exaggerated online fear, take a moment to support the channel. When accurate information reaches more people, panic decreases, and informed decision-making increases. That's always the goal here. There's also a psychological side to this conversation that we can't ignore. Even if the statistical risk is low, uncertainty itself creates stress. Many immigrants worked for years, sometimes decades, to secure permanent residency and then citizenship. The idea that it could be questioned feels deeply personal. But the best antidote to anxiety is understanding structure. The structure of American law still requires due process. It still requires evidence. It still requires a judge. Enforcement intensity may rise and fall with political administrations, but constitutional safeguards are not that easily dismantled. So, now that we've covered your legal rights and practical protective steps, we need to address another critical distinction, one that often gets lost in conversation: the difference between the security of citizenship and the vulnerability of permanent residency. Because if you are watching this as a green card holder, your strategic decisions in 2026 may be different from someone who is already naturalized. One of the most important distinctions you need to understand in 2026 is the difference between being a naturalized citizen and being a lawful permanent resident. These two statuses are not legally equal. A green card is permanent residency, but it is not permanent in the same constitutional sense that citizenship is. Lawful permanent residents can lose their status under a broader range of circumstances. Certain criminal convictions, including some offenses that may seem minor under state law, can trigger removal proceedings for green card holders. Extended trips outside the United States without proper documentation can raise abandonment issues. Failing to file taxes as a resident, claiming non-resident status improperly, or misrepresenting information on government forms can create vulnerabilities. The legal threshold for revoking a green card is significantly lower than the threshold for denaturalizing a citizen. That's why, if you are eligible for citizenship right now, waiting indefinitely may not be the safest strategy. Some people hesitate to apply because they're nervous about stricter interviews or longer processing times. But here's the reality. Citizenship provides the strongest layer of legal protection available under U.S. immigration law. Once naturalized properly, your rights are anchored in the Constitution. As we discussed earlier, stripping citizenship requires federal court litigation and a high evidentiary burden.